Most asset protection plans do not fail because they were illegal. They fail because the first time somebody actually pushes back a lawsuit, an audit, a family dispute, the plan turns out to be paper thin. I have seen multi-layer structures collapse in California in weeks. LLCs sharing bank accounts, operating agreements that never got updated or signed. No minutes, no documented decisions. A trust that is never treated like a real trust. And once a judge decides your entities are basically just you in disguise, the protection does not just weaken, it disappears entirely. In this video, I will show you the 4 failure points I see over and over again and how to build protection that is designed to survive pressure and not just look impressive at setup. I'm Ali Talai. I am a California asset protection and trust planning attorney and also a founder of Talai Law Offices. Today, I want to explain why asset protection plans collapse when they are actually tested, even when they were drafted by smart professionals, and what usually breaks first. Because failure in asset protection is rarely sudden. It is structural, and if you know where to look, you can see it coming before it is too late. If you want to see how I structure asset protection plans for real estate investors here in California, including LLC and holding LLC strategies, irrevocable asset protection planning trust, and layered protection, I walk through all of that in my free asset protection webinar. The link is on the screen and also in the description below. Most asset protection plans are not designed to be tested. They're designed to be implemented. They work beautifully as long as no one sues, no one audits anything, and nothing unexpected happens. But asset protection exists precisely because something will happen. Pressure is not a possibility, it is inevitable, and pressure exposes weaknesses that nobody saw during the setup phase. I spoke to a potential client whose asset protection plan was challenged in a lawsuit here in California. There were 2 property LLCs, a holding LLC on top, also an irrevocable trust that held the membership interest of the holding company. On paper, it looked fine. It looked great. 3 layers of protection. But when the plaintiff's attorney started digging in, it collapsed in about 60 days. And the reason was that all the LLCs shared one bank account. I'm not even sure how you open up a bank account like that, but they all had one bank account that all the income, all the rents, everything were deposited into. The operating agreement had never been executed. There were no meetings, no documented decisions, and the irrevocable trust had never been properly administered. The California court applied the alter ego doctrine. The judge determined that these entities were extensions of the client himself, not a real separate businesses. And once that determination was made, all of that liability protection disappeared. The plaintiff's attorney reached through every layer and went directly after the underlying properties. The client had spent over $40,000 on the structure. It collapsed not because the law was unfair, but because the plan was designed to look protected, not to function under stress. Okay, let's talk about what I think is the first thing that breaks with these asset protection planning. And usually what breaks is when I see that the behavior does not match the structure. On paper, there is an LLC. In real life, money moves freely between the personal bank account and the entity bank account. That is not good. On paper, there is a trust, but decisions are not documented. And the trustee is acting like a personal owner. Courts here in California do not just read your documents, they also look at how things actually operate. And when behaviors contradict structure, the structure loses all credibility. Under the alter ego doctrine, if a court finds that you treated an LLC as your personal instrumentality, commingled funds, no real records, entity assets used for personal expenses, the court will disregard the entity entirely. Your personal assets become fair game. That is not a theoretical risk. I have seen it happen to well-intentional clients who simply did not understand what maintaining a structure actually requires. The second failure point is discipline over time. And this one is sneaky because it happens slowly. Most people are careful at the beginning. Separate bank accounts are open, formalities are followed, operating agreements are signed. Then life gets busy. A record slips, Decisions stop being documented. New assets are acquired, but nobody thinks to put them into the right structure. The annual review with the attorney gets pushed back. When the plan is challenged, a court wants to see that you respected the structure consistently, not just the first year. So I had a client who maintained perfect records for 3 years, and then all of a sudden he stopped. 5 years of neglect later, a tenant dispute became a lawsuit, and the plaintiff's attorney pointed to those 5 years. The court agreed, and the LLC protection was gone. Asset protection, I'm telling you, it's not a one-time event. It's an ongoing practice that you have to do. All right, the third failure point is a structure that does not grow with the client. Plans are built around the facts that exist on the day they're created. But our life changes. New properties are acquired, but they never get moved into the structure. A business interest grows significantly in value, and the original planning no longer really fits it. A family situation shifts. The distribution provisions in the trust no longer make sense. When the structure stops reflecting reality, it stops providing protection. A Wyoming holding LLC that was set up to hold 2 properties but now sits above 8 creates exposure if the operating agreements, capital accounts, and records were never updated to reflect what actually happened. Courts look at whether the structure matches the reality on the ground. When it does not, the gaps become the weaknesses. The fourth failure point is complexity without purpose. More entities, more layers, more paperwork, but no clear reason why things are structured that way. I see this often with clients who come to me after working with a previous attorney or a package-based asset protection company. They have 6 or 7 entities, multiple layers, and when I ask them to explain what each entity does and why it exists, they cannot. And if they cannot explain it, their attorney cannot explain it in the court either. Complexity does not always equal strength. Unnecessary complexity attracts a scrutiny. It raises the question of why does this person need 7 layers if everything is legitimate? If you cannot clearly explain why an entity exists and how it operates, that entity is a liability, not a protection. If a structure cannot be explained simply, it is usually indefensible when it matters most. Sophisticated plans are built with testing in mind. They assume someone will look closely. They assume someone will question the intent. So they focus on fundamentals, real economic substance. Behind every entity, clear roles that are actually respected. Consistent documentation from the first year through the 20th year, and a structure that is updated as the client's life and assets change. So LLCs do not protect you if you do not respect them. Irrevocable trusts do not protect you if you do not administer them properly. Plans do not protect you if they only work when no one pushes back. If your plan requires everything to go perfectly in order to succeed, that is not protection. That is hope, and hope is not a strategy your family can rely on. Asset protection plans do not collapse because the law is unfair. They collapse because reality eventually exposes weak designs. The strongest plan are not the most complex one. They are the most disciplined, consistent, and defensible. That is what you should be building towards. If today's video resonated with you, in my next video, why asset protection plans fail in court and how to build one that won't, I go deeper on what courts and creditors are actually scrutinizing. Why looking uncollectible itself is a form of asset protection, and the honest truth about what asset protection can and cannot do, something most attorneys will not tell you. So please go watch that next, and I look forward to seeing you over there.